All right, guys. So IPR Laws, the podcast you've been listening to on all the major streaming platforms, but here we are still discussing certain topics which are really interesting. I have with me Shivaarti Bajaj, who's the co-founding managing partner of RSD Bajaj Global and iNeva. Shivaarti, lot of confusion between trademark and patents. लोगों को क्या लगता है ना, एक ही चीज है कि हाँ, अरे वो ट्रेडमार्क पेटेंट कराया है क्या? लोग बात भी ऐसे करते हैं. So let's first of all understand that what exactly is a patent.
Sure. Kabir, it's a pleasure to be here, firstly. And second, moving on to your question. It's a very good question from a point of view that people think patents and trademarks are same or that is what it is to IPR. But that is most certainly, as we have realized during this series, that it's not the case.
Separate.
It's separate. So, trademark, as we discussed in the previous episode, is a brand or a mark for a particular trade. It's a trade name. It can be a logo. It can be a word. Like Red FM is a word.
Bajate Raho is our tagline.
Bajate Raho is your tagline.
Yeah.
You are getting good.
Dekha.
So, similarly now, that would be a trademark. And now coming to patents, a patent is a little more complex in terms of it is an exclusive right for inventing something new. Okay. And when we say new, then it has to be on the standpoint of it being novel, inventive and industrially applicable.
Okay.
That is where a lot of our inventions fall into.
Majorly the inventions, your biotechnology, your pharma, your softwares, not per se, but embedded on hardwares like your IoTs. In India, softwares are not patentable per se, but they are allowed if they are embedded on a hardware. Okay. But in the US, patents are allowed as softwares. That's very interesting because that means if I have a software and there is a algorithm or a certain trade secret that I'm using, that is not patentable in India.
The software alone is not patentable.
It's not. No. If it is part of an hardware, it
yes,
can be.
It is.
Wow.
But then again, it needs to be looked into how you're presenting your invention to the authorities.
So okay, that's very interesting because I mean, patents can be, as you said, can be software, can be biotech, can be pharma. This is all patentable because it's invention. It's something new. It's something that you have probably researched or come up.
Something that involves a lot of R&D. Something
right?
That's not been done before. Like we discussed in our previous episode of traditional knowledge, GI, traditional knowledge and trade secrets. Traditional knowledge, a lot of traditional knowledge information that falls in
cannot
be patentable because वो as you were saying ना, दादी माँ के नुस्खे भी आप पेटेंट करने लग जाओ, जो कि कई बार
कोशिश करते हैं,
मेडिसिनल वैल्यू है उसकी.
टर्मरिक जो आपने एग्जांपल दिया था, ये हल्दी का.
हाँ, सो ये चीजें हैं उसमें, तो ये पेटेंट होंगी आपकी फार्मास्यूटिकल्स. Your like Dolo would be a brand name, but उसकी जो composition है medicine की,
उसका जो
salt है, वो
पेटेंट हो सकता है.
वो invention है.
So Dolo is the trademark.
Yes.
Dolo का जो logo है that can be trademark. पर उसका जो product है अंदर, जो medicine का जो salt है, जो composition है, that can be patentable.
Yes, absolutely right.
And what is not patentable then?
Oh yes. Good question. A mere discovery of known substance, like जो चीज़ बहुत पहले से exist कर रही है दुनिया में और आप you bump into it, आपको मिल जाए वो, तो आप ये नहीं कह सकते कि अरे ये तो मुझे मिली है चीज़, वो आपको नहीं मिली है, वो पहले से exist कर, वो discovery है.
So discovery.
The very thick line between discovery and invention. Anything that's hurting public sentiments, something that's a mere admixture, जैसे आपने red और येलो मिला के आपको ऑरेंज मिला, तो ये कोई पेटेंट
रीअरेंजमेंट,
mere rearrangement of known substances, ये सब चीजें पेटेंटेबल नहीं है by law. In the it comes under section 3 of the Indian Patent Act. And your plants, like as a whole are not patentable. Animals as a whole are not patentable.
कोई है कोशिश कर रहा है आज कुत्तों को पेटेंट कर लेता हूँ, सारे डॉग्स मेरे डॉग्स.
इसमें the debate Kabir is going is for your hybrid animals.
Oh yes.
That's a debate that
test tube animals and
yes. So usme bhi there are interesting cases of a sheep that was cloned.
Cloned,
and,
yeah.
Of there was once a patent given for a mice जो carcinogenic detection में help करता था कि cancer है कि नहीं particular उसको. So there's a separate thing to it. So traditional knowledge, as we've discussed, computer programs per se, business methods. Business methods are not mere presentation of information कि ये PPT मैंने ऐसे बनाई है, ये मेरा पेटेंट है. नहीं,
वो स्टाइल में आ गया.
वो स्टाइल है, वो presentation of information है, that cannot be patented. Patented is more deep. Your topography of integrated circuits are not patentable. But that comes under a different act altogether, under the IP umbrella. So that falls into that. So these are the few things.
So let's say if I am a semiconductor manufacturer and I know how to make a particular semiconductor which performs well at very low temperatures, right? Issue तो सारे processes का temperature ही रहता है. तो if I know how to do it, I have come up with it, that can be patentable.
So again, as we discussed, it has to be thorough on 3 parameters. Your novelty, which is what is the newness in it, inventive step, what is that one step you're doing that is taking it to that level.
Okay.
And your industrial applicability.
तो उसके अंदर
circuits per se, जो उसकी topography of the circuit will come under a different act. The
पर वो भी generic होती है, like that is not something which can be patentable, right?
That comes under Semiconductor Act actually, the Semiconductors and Integrated Circuits Act.
Okay.
But yeah, I mean the hardware can be a different thing. जैसे आपका Six Sigma system है.
Of quality assurance.
Quality assurance. Now it's very like known, right? But it is not.
It's the buzzword. People just flaunt that a lot on LinkedIn. Ki I am a Six Sigma black belt.
Yeah, like I think Six Sigma.
I think Six Sigma. Six Sigma is in my DNA.
Yeah, so that was like people went to Japan, they saw it, and then they kind of that's a method.
That's a business method.
Business method.
Yeah.
So
GE, if I'm not wrong, made it really popular. GE is
they even made the GM diet very popular.
Achha.
Yeah.
Okay, but when you say patentable, like, you know, there's this huge controversy, and it's always been actually, you know, and I know about this guy, I forgot the name, but he was infamously called Pharma Bro because he patented certain very generic medicines. जो कि आपको मान लो एक बहुत ही एलर्जी, एक बहुत यूनिक एलर्जी है जिसकी मेडिसिन मान लो 50 सेंट की आती थी अमेरिका में, और फिर और उसने क्या करा, उसने देखा कि अच्छा ये मेरे पास पेटेंट है, ये 50 पैसे की 50 सेंट की आती है, बहुत लिमिटेड ग्रुप ऑफ पीपल आर कंज्यूमिंग दिस, तो उसने उसको धीरे धीरे ना प्राइस बढ़ाना चालू कर दिया. उसने 50 सेंट से $500 की कर दी. ठीक है, तो biotech or pharma mein has always been like this, you know, this huge thing about patents. So what is the right now, what is the standing of patents with in biotech or pharma? यानी क्या, मान लीजिए डोलो ही है, ठीक है, वो तो कॉम्पोजिशन है, तो क्या मैं हमेशा अपने पास रखूंगा, कोई और बना ही नहीं सकता वो वाली पैरासिटामोल, क्या, how does it work?
So basically once a patent is granted, it is granted for a limited time of 20 years.
Okay.
From the date of filing or priority, whatever it is there. So after 20 years, it is open to the public at large to use the particular whatever's listed in that invention.
Okay.
So it's open for all. Like you can understand it as an open source after 20 years.
After 20 years.
But for the first 20 years, it is an exclusive right.
With
that is where your techniques, like if people want to go in for monopoly, but then there are like the example you gave, there are regulatory authorities,
which
the drug regulatory authorities, etc., that look into it. However, those are the 20 years that, you know, the bigger companies claim that we have put in the amount of R&D, the amount of dollar behind the research. हमने इतना पैसा लगाया तो हम उसको प्रॉफिटेबल तो करेंगे, तो वो उनकी आर्ग्यूमेंट है कि हमें क्यों चाहिए. बट हाँ, देयर आर लॉट ऑफ टाइम्स दे लाइसेंस द टेक्नोलॉजी टू अदर people to manufacture, to reach scale and you know, probably operate on the economies of scale, the price point नीचे आ जाए. Something that we observed during, you know, the times been very tough for the past 2-3 years. You know, we've all witnessed a very deep health scare, and so in that case the vaccine, you know,
nobody really patented it. It was open source. People could make it.
So everybody
So
was.
those are the things that can go into contributing towards a larger
betterment of
goal
humanity.
of humanity.
क्योंकि अब जैसे for example the cure for AIDS जैसे अगर किसी को मिल जाए completely, right? So that's a huge moral question. Like 20 साल तक.
So see, आपको वो right मिल रहा है, अब आप उसकी pricing भी आप decide करोगे. Maybe you want to be philanthropic about it, आप उसकी pricing नीचे रख लो. That's a business call, personally, I feel. But as an intellectual property right, it is your right to either sub-license it, license it.
It's up to me.
It's up to you as a owner of that right, or you want to sell it at 3,000 or you want to sell it at 3 rupees. वो आपकी मर्जी है.
Are there any other examples also, like जैसे कि for the betterment of humanity, जैसे COVID की vaccine आपने बोला कि everybody was it was not patented, like you could like use each other's research papers or probably build upon existing vaccines. Are there any other places also where people have not patented a particular biotech or a pharma?
Sometimes people patent, then they'll make it like that. अगर suppose आपका patent है और कोई और भी बना रहा है वो, so it's up to you to send a notice to that person or not. Sometimes you're like, ठीक है, open source है, you use it, or you take a formal license from me, don't pay me royalty, don't pay me. The arrangement can be
credit, probably.
Credit. So it's like a very famous case of Novartis AG versus the Union of India. In that case, it was highly debated कि उसकी थोड़ी सी ट्वीकिंग में थी या वो ज़्यादा ट्वीकिंग में थी जो the two parties, the salt that they had, because उसमें वो प्राइस पॉइंट में फ़र्क पड़ रहा था Novartis versus the other companies. So these are the things that come into play when we're talking about pricing. But patents, inventions have been on since the times that have been like Carl Benz, was one of the people who initially got the internal combustion engine, which is actually the backbone of Mercedes as a company right now. So there's combustion engine. There are a lot of car components that are there, mostly engines in terms of patenting, because there's a lot of R&D and technology that goes into it. Now that we're entering the EV world, so usme bhi there are a lot of
how you're managing the power,
your engine, there's a design and then there's a patent of the whole engine in question. So stuff like that, and then there are softwares. The whole world that we're entering into with the
completely algorithm software,
AI, ML. How does that fit? Because we are entering into a world of high R&D, and earlier R&D was thought to be only limited to maybe medicines or engines, but now it's become more fluid with the clouds and everything in place. So
so when it comes to patents, when was it introduced in India? Like, because biotech being such a delicate topic when it comes to patent, and we discussed that. India में कब आ गया?
So India में, Kabir Acts evolve. It was the Act of 1856. 1970 is the Patent Act 1970s, which is currently. But then there were major amendments in the 2002. The rules were, taken out. But patents, when we speak, and you touched the topic of biotechnology. So one of the earliest was the brewing of beer was considered one of the first uses of biotechnology.
Achha.
Yes.
Okay.
So that is where it's considered as an early use case of biotechnology as a solution. So
So in biotech also, biotech is huge, right? So though it sounds like one word, but aren't there like many streams through biotech? Broad sectors which we can talk about जहाँ पे patent होता होगा?
So biotech in fact is very old though, but it is a very new science in a way, because in the current scenario, a lot of R&D has gone into drug delivery. Going forward, we will have solutions like where a particular, like right now you have a medicine for one ailment in a particular area, but your whole body, it goes through the
entire
whole body,
system.
Entire system.
Fair enough.
Right? But with the drug delivery mechanism, we are getting things like wherein that it will be a targeted medicine delivery. The medicine will reach the spot, and that's where it opens up and affects.
हाथ में दर्द हो रहा है तो मुंह में खाने की जरूरत नहीं, क्योंकि वो पूरे सिस्टम से थ्रू जा रहा है,
अगर
कुछ
आप
और
मुंह
तरीका
से भी खा रहे हो तो वो आपके हाथ पे जाके इट विल
वहीं पे खत्म। उसके बाद ये नहीं कि उसका साइड इफेक्ट कहीं और कुछ और हो रहा है।
Yes. So this drug delivery, then this bioinformatics is involved in a big way in biotech to uplift the whole invention scenario, stuff like that. But if you're asking me about the history, there was the electric bulb with Thomas Edison in 1878. That comes into the patents. The television, your phone, Graham Bell, your internal combustion engine we've already discussed, right? Carl's Benz. Yeah, so I mean stuff like that. And a very interesting case that happened recently was the iPod, Apple company, Apple Inc. So they have pulled out the iPod from the market. But why I am bringing out the example is it's when it was patented, the 20-year period had expired, was over. So now it was in open source. Anyone can make that technology right now.
Although सब बना सकते हैं तो हम क्यों रहें? जाओ बना लो.
So they pulled out the product for different reasons, but just as an example, the technology is now available in the market for everybody to use, and patents is going to be a big backbone of intellectual property rights in the new age economy.
I'm sure.
With the Web 2 and 3 spaces and your inventions and your IoTs, your Internet of Things, the hardwares that are coming up with your because that's software embedded on a hardware.
That's patentable.
Like you were talking about an example wherein you have an interesting software on the mic wherein you say something and it gets converted into a particular thing and it gets uploaded on a file or so that would be an IoT.
That
mic.
would be an IoT, and that can be patented.
That can be patented. So,
but not just the software which does that.
Not just in India. In the US, you can get the software, and you can get the hardware separately, or you can get it together.
So consumer tech, I still get it. Like patents can work, like an iPods or whatever. Fair enough. Like at the end of the day, nobody's getting saved or killed by them, right? But how? What do you think is the issue with the biotech and pharma patents? Because I mean, going back to that, because I think that is a bit more delicate, right? Like because that's when we are dealing with zindagi, logon ki zindagiyan.
So no, there's a very stringent mechanism. There's R&D, there are clinical trials. Patent, you don't get a patent overnight.
Acha.
So after you file it, suppose in a country like India, it takes 3 to 5 years to get a patent through. It's thoroughly examined. The patent office has as a body has a group of learned examiners and controllers. Most of them are masters or PhDs.
Okay.
And engineers. They thoroughly examine the application, its implications. If it falls under something that's morally incorrect or of sensitive value to the government, such patents need to be kept handled differently rather than it just being public information for common use. So there's a whole mechanism in place, and now in fact the government is being very prompt towards the patents, because as we see with the quick change in the environment, technology has become the backbone. So having a good patent does give you a right to accelerate at a particular rate. Yeah. So that way, and for that reason, for a lot of startups and early stage companies and individuals, the official fee has also been reduced. The official fee is the government fee that you need to pay with each filing of applying for a patent. So has been drastically reduced, which is a great initiative to promote the same. So,
what will be the first basic step? Like, मान लीजिए मैंने कुछ invent कर लिया, वैसे तो नहीं करा, लेकिन मान लो कर लिया, तो what will be the first step for me to get in touch with somebody like you and then go through it, or can I file it on my own? Like, how does that bit work?
Of course, you can file it on your own. But for filing a patent, you need a certified patent agent. Right? Yeah. So, I mean, it's always better to go to the experts, not necessarily a lawyer, a patent agent, because that's a certification from the government of India, which is given to people who clear the examination. It's an examination by the
in Indian, like you can understand it as an Indian government's exam kind of a thing. So they need to sign the application and submit. So basically what happens is it's not only like you think of an invention and you file it, you have to draft it properly, you have to get enough evidence. A backbone which a lot of people miss in inventions is searches. I always advise that it's very important to search before filing, because that will give you like a quick landscape of what is there.
What is there already? ऐसा नहीं कि आपको लग रहा है कि आपके पास में तो already कोई बना चुका है.
Yes. So it saves you time and energy, and then after that you can go ahead with your drafting and filing, and then the prosecution takes around 3 to 5 years depending, but the time is reducing with the backlog decreasing. Everybody's working very hard because it is an important aspect of our current times. So उसको फिर उसी हिसाब से देना पड़ रहा है.
Can somebody also monetize patents? Let's say for example मैंने एक कुछ चीज़ इन्वेंट कर ली, स्मार्टफोन जो क्या कहते हैं आपके, मान लो कि कान से टच होके चलता है फॉर एग्जाम्पल, बहुत ही रैंडम चीज़ बोली है मैंने, लेकिन फिर भी but can I monetize that patent? Even if I get that patent, can I give it to like other people? Like what happens? Like,
of course.
Apart, if I just don't want to manufacture it, मेरे पास उतनी capital नहीं है भाई कि मैं बना नहीं सकता हूँ. Technology मैंने बना ली, लेकिन मैं और मेरे को investor भी नहीं मिल रहे. तो can I like give it to other ways to monetize it?
It's a very good question, Kabir, because a patent is an inventor's friend. Right. Okay. So suppose you've come up with an invention and it is groundbreaking. Of course, you can get a patent on that, and you can license your technology to bigger companies. Sometimes it's called technology transfer. They either have an agreement to buy it out from you. At least you get a monetary value for your intellect, for your effort, for your invention, and you can license it and probably get a royalty over it for its production, etc., etc. There are a lot of ways and means around it, because that's the whole backbone to enable the people who've put in the R&D in time to get a return on their effort, howsoever they would want to.
Interesting. So I want to conclude by just asking you that, see, today youngsters are into a lot of startups. Startup being the buzzword. They might be sitting on something which is gold, right? करवाना चाहिए या फिर थोड़ा वेट कर लें? क्या करना चाहिए?
Of course करवाना चाहिए, because this gives you an exclusive right to monetize or use your particular invention. करवाना चाहिए is also like the end goal. आपको मिलना भी चाहिए. You need to apply.
That's a long process.
Yes. It's not long as such anymore. It's reducing as we speak. But it is essential because that gives others a right to not use your invention and gives you the exclusive right to use it for 20 years. And if you want to be philanthropic about it, go ahead. License it for free. But if you feel you've put in X number of years, dollars and efforts and monies around it, then you probably want to go and monetize it. So it is the backbone of everything called invention under the
right
umbrella
now
of
with
IPR.
Web3 happening. Everything is an invention. It's
yeah. I mean, IoT is more so, like your robots.
Everything like
jumping.
There are like robots who can clean your house, and that's an IoT again.
Yeah.
I think किसी ने तो पेटेंट करा ही रखा है, और I think it's a consumer good है. तो ऐसे तो काफी कुछ, I think जेटसन वाली एज ज्यादा दूर नहीं है.
Yes.
है ना?
How we moved from Flintstones to Jetsons in a jiffy.
Yeah, exactly. But in a jiffy, we gave you some lowdown about patents, and if somebody wants more information about patents or anything related to IPR, how can they get in touch with you?
Sure. They can send us an email on the law firm's ID, rsd@rsdbajajglobal.com, or any of the social media handles which are active on all the relevant platforms, Twitter, LinkedIn.
Brilliant. So that's Shivaarti Bajaj, co-founding managing partner of RSD Bajaj Global and iNeva. On that note of 100 rupees, we shall move on to the next one. So watch out for that one.
Thank you, Kabir. It's been a pleasure having this conversation with you.
93.5 बजाते रहो.